People v. Weber.
Good afternoon. Excuse me. May it please the court, Dave Juergens with the Monroe County Public Defender's Office. If I may reserve 2 minutes for rebuttal.
Yes, sir.
Mr. Weber's asking this court to reduce his SORA classification to risk level 2 based upon a correct assessment of 100 points at the SORA hearing. The issue before this court is whether the people forfeited their right to appellate review of their request for an upward departure because they never raised it at the initial SORA hearing. Or does the appellate division have unfettered discretion to grant the state remittals upon request? I think the legislature drafted a statute here that gives us our answer. CPLR 5501A1 basically gives respondents on a defendant's appeal the right to
Counsel, let me ask you this hypothetical. The REI comes in and it's a level 1, and the people say it's wrong because they shouldn't have got acceptance of responsibility points, let's say. And the SORA court agrees with them, and they say, you know, you're right on points, this is a level 2. And it goes up. No, the SORA court disagrees with them, and they say level 1. You know what, level 1, this is a level 1, and the defense says, great, people appeal on the points, and they win. They win on the points. So now the appellate division says this is a level 2. And the defendant says, you know what, I want an opportunity to go back and argue a downward departure now to level 1. Would the defendant have that right?
Absolutely not, because the defendant didn't preserve his right to request a downward departure in the alternative.
Even though the defendant won?
Well, the defendant won, but the defendant was on notice that there was a possibility that he was not going to prevail on an appeal and that a level 2 could be the result. And in that case, he had every reason to make a request for a downward departure if the record would support that.
So in this case, did the people request an upward departure in the alternative in the event that they did not get the level 3 adjudication that they were looking for in the SORA court?
No.
So is your argument that you get the benefit of going back to argue for the upward departure, but in Judge Garcia's hypothetical, the defendant wouldn't get the benefit of going back to argue for a downward departure on a level 2 adjudication in the appellate division?
What I'm saying is that you have the SORA hearing and the points are contested. Both parties are on notice that if they want their targeted risk level to be affirmed on appeal, they need to make arguments on the points, and if there's a basis for either an upward or downward departure, they've got to put that before the SORA court in the first instance.
Wouldn't this entire appeal have been completely obviated if there had been an alternative argument made for an upward departure before it went up?
We wouldn't be here if the people had made, in the first instance, an argument that they should get an upward departure, and in that case, the appellate division would have looked at both arguments, the points and the departure issue, and rendered a decision at that point. But that's not what happened. The people never made that argument, and they basically got a mulligan when they asked for remittal, and it was granted. And a lot of the cases that we're looking at in the SORA context, especially the older ones, it's hard to determine the basis for the remittal by the appellate division, because...
Do you think that was the appellate division's exercise of their interests in of justice review? Like, how did the remittal come about? What do you think?
The people are relying on CPLR 5522A to try and say that the appellate division has discretion to grant remittals. But they're misreading the statute, and it goes against this court's case law. That doesn't expand the scope of the review for the appellate division. That is a broad statement of the general powers that the appellate court has when they're considering appeals in general, but
Well, is that limited actually to the appellate division, or does 5521 read on us as well?
I believe it applies to all appellate courts.
So if you were reading that as the power to do that, it really couldn't be the interest of justice power, because we don't have that.
True, true. And the people are, again, misreading 5522A, and this court has said specifically that neither CPL 5522 nor any other statutory or constitutional authority permits an appellate court to exercise any general discretionary power to grant relief to a non-appealing party. And that's what we have. The people are a non-appealing party. They're piggybacking, looking for relief, affirmative relief on the defendant's appeal, but they didn't preserve their right to have that review. And in this court, the site I just gave was Hecht v. New York, 60 New York 2nd, 57. This court in the parochial bus systems case, that's 60 New York 2nd, 539, basically read the statute 5501A1 and interpreted it as having a preservation requirement. They said that a respondent, a non-appealing party, yeah, you can have appellate review if we're looking at the error that the lower court committed and has been properly preserved, and if corrected, would support a judgment in the non-appealing party's favor. And if...
Can I ask you a different kind of question, and to see if you think it at all affects your argument? Let's say a defendant does not preserve, has not raised to the SOAR court a request for a downward departure, but makes the argument to the appellate division. Can the appellate division exercise its interest of justice jurisdiction to, and if there's enough of a record, to entertain that request and grant the downward departure?
That is a area that I'm unclear on, because I've seen many appellate division cases where interest of justice jurisdiction is exercised, but typically it's done so in the context of some sort of a due process, lack of notice, some sort of constitutional grounds where, because, I mean, even though
Are
SORA...
you thinking about criminal cases there?
Yes, and there's a...
This is not a criminal case.
Right, right.
You're right.
So there's a specific statute regarding interest of justice jurisdiction over defendants, and I see my light is on.
Continue.
But that's not something that we have in civil cases.
But wouldn't a practical effect of a ruling along the lines of what you're asking for mean that in any case where there's contested points, the people ask in the alternative for an upward departure? And I can see a string of decisions then that in any event, they didn't abuse their discretion in granting an upward departure to the extent the points aren't properly awarded here. And an upward departure decision is, as you know, a much less probing standard of review. So wouldn't you want a court actually reviewing point allocations and RAI scores rather than just saying, in any event, the court didn't abuse its discretion to the extent the points weren't included in the properly included in the RAI to upwardly depart?
Well, I believe the SORA court should make determinations on both the points and if there's a request
But
for...
yours argument is a preservation argument, not a determination by the trial court. So I think all the people have to do is throw the flag in there and say, in the alternative we ask, they've preserved. Your argument isn't the SORA court has to decide it, right?
Well, the people didn't even do that in this case, but if the people had said, you know, we would like to reserve our right to make an upward departure request, I'd argue that's still not enough, but it's
But no,
better
let's
than...
say we want an upward departure in the SORA courts, in the alternative, and the SORA court says, why would I give you that? I've already ruled on your points argument. You're a level 3. I'm not in the, I'm not in the business of making advisory rulings.
Then the people are golden. The people are golden.
Why wouldn't they just do
because-
that all the time?
Well, they could, and maybe they should. If there's a basis for their target risk classification that's supported by the record, I mean, courts expect litigants to come prepared with their best evidence and their best arguments, and that's all we're saying should happen here.
Thank you.
Good afternoon. Marty McCarthy for the Respondent, Monroe County District Attorney's Office. I want to start where you just finished, and then I also want to address your hypothetical you asked at the beginning, Judge Garcia. I think that's a terrible idea to constantly ask for upward departures all the time. To me, that would then increase the likelihood of a defendant, criminal defendant, getting an upward departure.
Are you saying it's a terrible idea to argue in the alternative?
With respect to whether, if I was a criminal defense attorney and I wanted a rule that required the people to always ask for an upward departure, I wouldn't want that rule.
Well, how is it any more unfavorable to allow the appellate division in its quote, perhaps in its interest of justice, to remit so that the people can request an upward departure, but not uniformly apply that and let a defendant do that? Because we have cases where on occasion the appellate division does not let the people do that, and on occasion where it doesn't let the defendant do that. I'm just saying, how is it any less favorable to the defendant to continue perhaps a non-uniform application as it now stands?
I think that may go to the hypothetical that was asked, and let me move to there right now. When you talk about the issue of notice, what is the prosecutor's obligation for notice? It's contained in 168N, and the only obligation there is for the defendant. If the people disagree with the board's assessment, then they have to provide notice. When you talk about a SORA hearing, a defendant doesn't have the burden of proof at a SORA hearing. So if the board's risk assessment instrument comes in as a level 1, at that point, the defendant has no burden. And if, to follow Judge Garcia's hypothetical, the court determined, nope, I read the board's risk assessment instrument, and I agree it's a level 1, at that point, the burden would never shift from the defendant. If the people appeal, which they have the right to do under 168N, at that point, the defendant can do exactly what the people did in this case. Ask for in that case, a downward departure. And in that scenario, under 5522A, the appellate division could remit for the purposes of determining that downward departure, because at the time...
It does seem to be a bit of a waste of judicial resources.
Well, the concept, you have stressed in Gelati that SORA should proceed in an orderly fashion, right? So the possibility of a departure, upward or downward, doesn't really become relevant until the points are assessed.
Well, see, but this is civil litigation, and which is what I practiced for a very long period of time. And the orderly process for civil litigation would mean that if I have a claim for breach of contract, and I have a claim, in the alternative for quantum merit, quasi-contract, unjust enrichment, whatever the other claims I might have would be, I've got to plead them all at once. I can't go up on the contract claim, win in the district court or the Supreme Court, go up to the appellate division, lose there, and then get a remittal to try another theory. And that's what's happening here. And that's the point about the waste of judicial resource.
And obviously, as a civil litigator, and it's been a while since I was a civil litigator, but the pleading requirements under Article 3 require that you plead causes of action in the alternative. Our pleading requirements are contained in Correction Law 168N. We don't have those requirements. You're not required
to plead in the alternative. If you choose not to, you lose the claims you didn't plead.
Correct, but in the end, you still have to put your causes of action in a pleading in Article 3.
And why shouldn't that be the rule here in this civil litigation?
Because our pleading requirement, we don't have pleadings. We don't have some. It would be better if we did, because then we wouldn't be here talking about this. But we don't. Our pleadings aren't Article 3 pleadings. We don't have a summons complaint. We don't have an answer. Or a special proceeding on Article 4. We don't have petition and answer.
Right. Instead what you have is a procedure that says the board puts in a recommendation, and if you want a different recommendation, you've got to put it in.
Correct.
Whatever it is.
And that's the thing. We didn't. We agreed with their assessment in Level 3,
so
and that's it.
Let me ask it this way. Could you then say, we disagree with the board on Factor 5, and seek a point total on that basis, win on that in the SORA court, go up on appeal, lose, and then go back and try on factor 8 or on factor 15. You have no pleading requirements.
Well, well, we did, actually, because you just articulated them. Because you said that if we ever disagree with the board's assessment, we have to then, in essence, enter a pleading. We have to enter our own risk assessment instrument, and if our risk assessment instrument, I think your factual scenario was same points, just different categories, we still had to do that, right?
And you don't have to do that for upward departure.
Well, I think the argument would be no. And, well, because in the essence, no, because the board's position was level 3. And we weren't disagreeing with the board's position, we were disagreeing with the board's point. But
Counsel,
let's-
I'm a little confused about how things work in the real world. In the last argument that we had here, one of the attorneys said something very interesting, and I wrote it down. The quote was, "Many times the people request an upward departure in the alternative." I wrote it down because I knew this appeal was coming up next. And now I hear you saying that that's, not only is that not the case, that maybe that's not even permitted in these hearings.
I wouldn't say it's not permitted, I would say it's not required, and there's a difference between those.
Okay, that's true, and I
Yes.
understand that distinction. So,
Is it permitted? Probably. It's certainly
doesn't
not
it-
prohibited, and
doesn't it
anything not
happen-
prohibited is
doesn't it
probably
happen
permitted.
often?
I'm sorry, I talked
Doesn't
over.
it happen often? Often. Doesn't it happen often?
I don't know if it happens often, honestly, that a prosecutor asks for,
So when Mr. Castner said he does 50 or 60 of these a year, 40 or 50, whatever the number he said was, says it happens often, you don't have a reason to disagree with that.
well, he's also doing them in a different jurisdiction.
Okay.
So.
What would the circumstances of an alternative be? So if you're the people and you disagree with the RAI assessment of points and you think there should be more, then you might argue in the alternative that absent finding more points, I want an upward departure. Right? That's a different argument to me. Right? If you disagree with the RAI comes in at a 2, you say, no, think he gets 20 more points for X factor, and I want a 3, then you might make an alternative argument that if you don't give those points, I want a 3 as a departure.
Then,
And I think you would have to.
well, because our requirement to articulate our basis would be different. So, yeah, maybe that, in that scenario.
But you're
when-
disagreeing with the RAI.
Yeah, in that scenario, because we're disagreeing with the RAI, we're also disagreeing with the level. But in any event, let's say we're not. And I think this was your point, Judge Carantaro. Let's say the points were the same. I think it's arguable that, yeah, the people may have been required, or the level's the same. The people may have been required, if the people disagreed in any way with the board's determination, that they would have had to put in their own point determination and ask for the departure because they were disagreeing with the board.
I think
But here, that's not what happened.
That's a fair point. And, one could make the argument, we didn't have to request an upward departure because we thought he should be level 3, and that's what the RAI recommended as well, and that's in fact what we received from the SORA court. But that goes back to Judge Garcia's hypothetical that we've been talking about throughout the argument. Wouldn't that same process have to work in the inverse of that case, where a defendant is hoping to get a level 1, gets the level 1 from the SORA court, goes up to the appellate division, the appellate division says, oh no, it's actually level 2, we've exercised our review power, and we see level 2. You have to give them the opportunity to go back and ask for level 1,
I
right?
don't disagree with that at all.
On a downward departure.
Don't disagree with that at all. And the simple fact is, it's not relevant until the points have been assessed.
It is inefficient, though, as Judge Rivera said a little while ago.
Well,
isn't
once
it?
upon a time, when I practiced civil appeals, they're not certainly as efficient as criminal appeals. But
Let me
granted.
ask you this. Let's say the court indeed goes above and does a level 2, let's just take level 2. Can the defendant then ask for reconsideration and at that point make an argument for a downward departure?
I'm sorry, you're talking about at a trial level, right?
At the SORA hearing,
Yeah,
often the
but at
court
the
will
trial.
on the record
Yeah.
say, give its analysis and indeed say what is its resolution of what should be the appropriate risk level, and then subsequently put something in writing
Yeah.
or rely on that transcript.
Yeah, and I think, I don't know if I want to recount what happened during the last argument, but this wasn't a sua sponte scenario, and I think what you ought to avoid is a sua sponte scenario. If a defendant, and that's in your,
Yes.
your hypothetical, if a defendant finds he's a level 2, at that point, yes, it becomes relevant to him to get a downward departure. He should be able to ask for a downward departure. He should get the analysis of that downward departure. It shouldn't, the court should not say, well, it's too late now, because it's not too late.
Well, what about, like in this case, where they ask for the downward departure, aren't the people on notice of what, the judge might agree, and maybe I should now ask for an upward departure?
I don't know if I followed that question.
Well, if a defendant asks for a downward departure,
A downward departure from 2 to 1.
well, 3 to 2, 2 to 1, take
Okay.
your pick. You're going downward either way. Aren't the people risking?
Well, I just wanna make sure-
Aren't the people risking a couple of things? Number one, if they don't do anything, maybe they object, but they don't do anything else. Number one, that the court might actually grant that downward departure.
Okay?
And before the appellate division might decide, I'm not going to remit.
Not gonna
Let you
run-
ask for an upward departure.
Well, we wouldn't be able to at that point. If, in your factual scenario, what's happening is the people seem to be satisfied with whether it's a level, that the points were correctly assessed, and that the people are satisfied that that's the correct assessment, right? So let's just say it's a 2.
Okay.
And the defendant goes through the departure analysis and says, I'm entitled to a downward departure, and puts forward evidence. And at that point, he does now have the burden by a preponderance of evidence to do that. If he does that and the court finds he's level 1, that's it, right? The people go up on appeal. What the people have to argue on appeal is that the court erred in finding those factors, but the court can't, the people can't ask for an upward departure from 1 to 2 at that point, because that's not how departures work. You depart from the presumptive risk level.
I see.
You don't go from, okay, well, this is a departure from the presumptive risk level of 2 to 1. The people then can't turn around and say, well, that departure from 1 is not proper, let's go back to 2. That's not how it works.
Why not?
One party gets a departure. It's either going to be upward or downward.
Well, why is that? I mean, couldn't they be based on different types of evidence?
Well, in terms of, well, you start with, again, you have to, what, the focus of the SORA hearing is twofold. First step is to make sure you have the presumptive risk score, whatever that is, right? And then from there, the party that feels that they should go up or down has the opportunity to go up or down. And yes, there are different factors for an upward departure and different standards of proof for an upward departure versus a downward departure.
Right, but here,
And in-
what you're asking is, and what the court allowed, is for the people to go back and articulate reasons for an upward departure where they hadn't requested one.
But we didn't need to request, if this had come in as a level 2, and I think that we're back to your hypothetical again. Let's say this came back at a level 2. It
No,
may-
sorry, what do you mean by
no, I'm
came
sorry,
back?
but my question is, why on the remittal can't the defendant now say, no, I want a downward departure, and here's some additional proof?
I'm sorry?
Why on this remittal that you would like to have allowed, can't the defendant come back and say, I'd like a downward departure based on the following additional proof?
A downward
can.
departure from a 2?
Yeah. Or if you're going to go up on the 3 for the following reasons the people give me, I would like to come down.
Because once the points were assessed and he was found presumptive level 3, it was at that point he had to plead to request the downward departure. The points had been assessed at that point.
Am I understanding the facts correctly that the defendant challenged some of the point allocations, you disputed them, but then on appeal, it looked to me like you conceded error with respect to one of the factors, forcible compulsion. Is that right?
That's factually correct.
Okay,
It
and
wasn't me
so-
personally, but yeah, that's
I
factually
didn't mean
correct.
you, I meant your office, right. So if that's right, then this all would have been avoided, I take it, had that been clear in the first instance? Had the people been clear about the absence of sufficient proof in the
Well, that-
first instance? It
That
seems like-
mistake was also made by the board. So in terms of that mistake, that wasn't as, you say, oh my God, the people conceded, it must be blatant. I don't know if it was blatant, but I think it was legally correct. And I think those are two different things. This was not a scenario where like, oh my God, this is a blatant error. It wasn't a blatant error, but I think
I'm not just-
legally correct. That's why we conceded on appeal, because it was legally correct, but it wasn't so glaringly obvious.
I'm definitely not taking issue with your concession. I'm simply saying it seems to me an unusual case in that the reason that you needed to seek the remittal in part, was that you conceded that you were abandoning the position on that particular factor that you took below. Is that
Yeah,
right?
because it was legal, because we also have an obligation to not make frivolous arguments.
I'm not
Yeah,
disputing
so,
that at
yeah.
all, to be clear.
So that we were constrained to do that, because we have to.
But if it had been clear before the court in the first instance, then we wouldn't have been in this situation, I take it.
I think in that scenario, if it was a level 2, then yes, the prosecutor would have been obligated at that point to ask for an upward departure.
So I'm sorry, we've gone through so many permutations. I'm not sure you answered this, and my apologies if this requires you to repeat yourself. But here, as I understand, the defendant did ask for a downward departure and was denied. But let's say for one moment he didn't. Let's say he didn't. And he goes up on appeal. The court remits to allow, I'm not sure I'm making the right hypothetical here, but the end of this question is, if the court is going to remit for an upward departure, does it also have to permit the defendant to seek a downward departure?
I don't think so, and the reason for that is it goes back to the parties' respective obligations at the time the risk assessment points are determined, the presumptive risk score. So once the score comes in at a particular level, let's say level 3, the people are under no obligation to ask for anything else because they obtain their level. The defendant there is obligated to ask for a downward departure. And I just want to make one final point with respect to remittal. When this case was remitted, the remittal court, when it was remitted back to the trial court limited the proof to say nothing can be introduced into this case.
Yes, that was in response to the defendant's motion. That was an alternative argument. Would it be a different case if the court said, no, I'm going to let them add more into this record?
I
Create
think,
a more robust record? Would it be a different case?
I don't think so. I don't think so.
Counsel,
why
can I
not?
just ask you, that hypothetical, I'm sorry, Judge.
No, I'm just curious. Why
That
not?
hypothetical, would that be a preservation issue? I mean, if you're going into the SORA hearing and the RAI says level 3 and the people are coming in and they're asking for level 3 and the defendant at the SORA level doesn't ask for a downward departure, could the appellate division say, well, we're modifying the judgment in some way, but we're going to let you go back and now ask for a downward departure?
Well, the appellate division has broader authority than, in terms of broader review powers than the Court of Appeals in that sense. It is a preservation issue because at that point when it was a level 3, the defendant was obligated to ask for a downward departure.
Could they permit it in the interest of justice? I can't think of the hypothetical right now, and there are too many out there, so I won't try. But could the court remit it in the interest of justice and allow an application for a downward departure?
I imagine if there had been anything in the record that would have demonstrated the possibility, that could have fallen under the necessary or appropriate case under 5522.
Well, what if the defendant does exactly, well, I think it's exactly what went on here. This was the one I was trying to think of. Tries to get the point reduction based on the argument of Ford. Court doesn't agree. Asks for the downward departure. Court doesn't agree. Appellate division and the people concede on the points, so you're now at the lower level, but sends it back for the upward departure. Why isn't the defendant able to now argue for a downward departure from the 2 as opposed to the 3? If the people are going to be able to argue, go up from the 2 to the 3.
I'm pausing because I just want to make sure I understand.
I know, the permutations are terrible.
There were a lot of permutations there, so.
I'm glad I'm not in your shoes there.
I think what happened is in your hypothetical, there was originally a 3, defendant asked for a downward departure, was denied, went to the appellate division, right?
Correct.
And then the
Division
points
decides on the
changed.
points, it is really a 2, not a
It's really
3.
a 2. In terms of the departure analysis, I mean, theoretically speaking, because that's all we're doing right now, this is theoretical.
Because it sounds to me like the division is putting them back into the place that they were, so why can't the defendant now argue, I want to go from 2 to 1? It's a much bigger lift to say I want to go from 3 to 1 than it is to go from 2 to 1.
And I think when it comes down to departure analysis, I think the crucial to that analysis is the point value. And if that's the case, if the point values change, then theoretically speaking, then the departure analysis should change too. I don't know if that answers your question, but
Thank you.
I
Thank
don't know if I disagree with you in your
Uh-huh.
hypothetical, because I think the overwhelming factor that starts all this is the point, the presumptive point value.
Well,
And
the
people
goal,
should
but
know
the
what
goal
it
at the end
is.
of the day is to get the proper risk level assessment.
Absolutely.
That's the point of the day.
That's the
Whether
point
it's
of the
on-
statute.
Whether it's based on points that the court agrees, yes, the points that are allocated, that are recommended, do indeed persuade the judge that that's the proper risk level, or the judge believes it's too high, or that risk level is too low, and addresses that through a departure. The end result of this is supposed to be an accurate risk assessment.
Correct, and as long as the defendant receives notice and opportunity. Any other questions?
Thank you.
I'd just like to point out that the people didn't give notice here, which I think makes their position even worse. And the way this case was briefed.
No notice of the request for the upward departure?
Yes, yes.
But there is there not a time between the remittal and when the hearing is held?
Well, we're not arguing lack of notice at the remittal hearing. We're saying that the fact that there is a requirement that they give notice for an upward departure, it undermines their argument in their briefs that how can they possibly make an argument in the alternative, because they have points for level 3 and there's no level 4 to go to. I mean, that's one of their arguments. Basically, what we're asking is that the court adopt the current rule from Third Department, a bright line test, and that very simply states that the people did not request a upward departure in response to the defendant's challenge to the point assessment or to the classification. And here, the people were on notice that the points were contested. They were on notice that Mr. Weber was arguing for a downward departure. They had every reason to request an upward departure at that point. They were on notice. They have no excuse for not bringing it at that time. The fact that they were saying that,
And then that notice would require 10 days under the statute? To put off the hearing 10 days?
well, there could have been, if the defense attorney felt the need to make an objection at the SORA hearing, would have been entitled to 10 days, but that's, as the court knows, excuse me, that's a separate issue. But,
Doesn't the appellate division have the authority to send cases back for corrective action? Like, let's suppose this was a criminal case and there was an ID procedure that they deemed was improper, and they say, okay, send it back now for an independent source hearing. Why is this any different?
because I believe that affirmative relief to a respondent on a defendant's appeal is governed by 5501A1.
Why can't it be interest of justice?
Because this court in People v. Hecht said that the statute they're relying on, 5522, does not grant general discretionary authority to the appellate division to grant remittals, to give discretionary relief. The statute governs the scope of review. The people did not allow the appellate division the first go-round to address this issue properly because they didn't preserve their request for an upward departure at the initial hearing. They forfeited their right to appellate review. It's straightforward, and the statute's neutral. It applies to both parties. If the defendant had won on the points at the hearing and remained silent, and the people take their appeal, and the defendant's now a non-appealing party, the people take their appeal, they get the level 2, they get the higher level reinstated. The defendant has no grounds to ask for the case to be sent back. The defendant,
So if it's, okay. So if it's the defendant appealing, but they didn't ask for the downward departure, just
Right.
appealing on the points,
right.
the court is unpersuaded at the appellate division. Can the
Right.
defendant ask in the alternative, can I now get a chance to ask for a downward departure?
And he hasn't preserved that. So the court would deny it.
Even though they're the appealing party. But because the
It's-
appellate division has interest of justice jurisdiction to address an unpreserved.
I think the appellate division has broader powers when they're looking at the remedy to the appellant. They can look at the entire scenario, but when they're looking at what remedy to give to the non-appealing party, they're restricted by the statute and by this court's interpretation of that statute in the parochial bus systems case that says you must preserve it. If you're the non-appealing party, you must preserve an issue. And plus, what error are the people pointing out? What error did the SORA court commit at the initial hearing? There was no error. They didn't preclude the people from arguing for an upward departure. They didn't.
Counsel, just, this is a very different question, and I don't know the answer to it, but there is a provision that someone subject to SORA can come in and periodically ask for an adjustment of their level, right?
Well, both parties can, both sides, there are certain grounds you can come in and ask for downward or upward modifications.
Both parties, and is that based solely, though, on changed circumstances over the
Yes.
time? That's what I
Yes.
thought. Thank you.
Thank you.
Thank you.